Hello and welcome to this week's edition of Wednesday Wisdom. My name is JB Hilliard and these are short video snippets designed to answer questions you may have about estate planning or probate, or maybe there are other legal concerns that may be impacting your household. And for this week, I thought I'd stay in the estate planning space. And so let's just talk hypothetically for a second. So let's just say you've spent hundreds or maybe even thousands of dollars on your will or trust estate plan package. And one of the most common misconceptions I see is people believing that their will controls everything that they own, and it doesn't. There may be one simple form that you've forgotten about that could control where some of these assets that you've listed in your will or trust actually go after you pass away. And that's what we're going to briefly talk about today. Now, certain assets pass according to contract or what we typically call beneficiary designations, regardless of what your will or trust says, which is why these types of assets are considered non-probate assets, because they're essentially designed to not have to go through the probate process, because they're designed to not have to be included in a will. That means that the beneficiary designation of such assets controls where those assets go. For example, we're probably all familiar with one of the most common types of assets under this category, which is a life insurance policy. But then there are IRAs or 401ks, there are annuities or other transfer-on-death investment accounts, and then there are payable-on-death bank accounts. Now, this becomes a problem when people forget to review those beneficiary designations. For example, let's say you got divorced 10 years ago, or even last year, but never changed your beneficiary from that ex-spouse's name. Or the person you listed as your beneficiary has unfortunately passed away. Or the beneficiary you initially listed was your child right after he or she was born, but you never revisited the form to update it after the second child or the third child or every other child after that was born. Or you created a trust but never coordinated your beneficiary designations with the rest of your estate plan. It's not uncommon for me to review an existing estate plan for a client and find that their will or trust says one thing, and then the beneficiary designations, if there are any, or if the client has any idea what they are, say something completely different or completely contradictory to their current preferences. So when was the last time you reviewed the beneficiary designations of your accounts, your life insurance, your retirement accounts, your bank accounts? Did you take the time to review those beneficiaries since a marriage, divorce, birth, death, or other major life event happened? And if you don't remember the last time you reviewed those, or if you ever have, then that's a telltale sign that it's probably time to take a look. So here's your homework assignment for the next week. Look at your insurance policies, your retirement accounts, and any payable-on-death accounts, especially your bank accounts. And review every beneficiary designation and ask yourself just these 3 quick questions. Is this person still living? And if so, is this person still the right choice? And does this designation match my current estate plan? Now remember, estate planning isn't just about signing documents. And sometimes the most important document isn't the one sitting in that estate plan binder or folder that you got from that signing meeting. It's that beneficiary designation form that you haven't looked at in years. And a beneficiary designation form that takes 5 minutes to review today could prevent a major family dispute later. So bottom line is this: it's all about making sure all the pieces fit together. And with that said, as always, I thank you for watching, and we'll see you next time.